2022, cold night, real cold night. Met back at the campus when the leaves were gold. Short time, just a little spark in the story stall. Long gap in the middle while we went our way. 10 years later, he pops up in my tray with a badge and 2 kids. Back on the force, Boston streets got him staying the course. January coming in sideways. McCarthy's had the drinks flowing all night. Moving down to the waterfall under white lights. Flakes on the window, tension in the air. But John never came back home. Left him lying out there in the snow on the lawn. Found him at dawn. Where's the truth at? Looking at the girl while the blue wall hides. Left him lying out there in the snow on the lawn. Yeah, he's gone. They looking at me, ignoring the door. Looking at me. Walk to the Fairview party past 12. Rough patch smoothed out, thinking we were good, but they built the trap. Big house, brass on the mantle and blood on the grass. Don't knock on the wood, don't ask the brother. Pin it on a lady, hide every other factor. Frame a story, tight like a movie actor. January coming in sideways. McCarthy's had the drinks flowing all night. Moving down to the waterfall under white lights. Flakes on the window, tension in the air. But John never came back home. Left him lying out there in the snow on the lawn. Found him at dawn. Where's the truth at? Looking at the girl while the blue wall hides. Left him lying out there in the snow on the lawn. Yeah, he's gone. Search the house. Why you never search the house? Ask the crew. Why you never ask the crew? Check the tape. Why you never check the tape? But John never came back home. Left him lying out there in the snow on the lawn. Found him at dawn. Where's the truth at? Looking at the girl while the blue wall hides. Left him lying out there in the snow on the lawn. Yeah, he's gone.
Good morning, everybody. Good morning, James. Good morning, Zach.
Good morning, James. Good morning, Zach. Hey, Zach.
Good morning, Mitchell.
Oh, hey, good morning, Mitchell. Yes, and please drive by that like button.
Yes. Okay, so we are done with Dave out. We did that yesterday. That was a rough day. My husband was like, "Why are you crying?" And I'm like, "We're watching the sentencing for Lori in Arizona." He's like, "Oh." I'm like, "Yeah." That was rough. And you may have noticed that
It was a
hi.
what?
I'm in the process of uploading. Can you guys hear me? Do I have to turn my mic up? Is
Yes.
that better? Is that better?
Yeah, that's better.
I am in the process of uploading all of the videos I got from the Mega Fundraiser on Sunday night. You may notice in some of them, I don't have the entire thing because I wasn't trying to record the entire thing. There are some panels where I do, like Melanie and David. Like I got most of that, if not all of it. But yeah, so
Good.
and it's only
awesome. Because if there's any part of the fundraiser you didn't see, or if that's part of the fundraiser you didn't see, you need to go and check it out. Because because that was amazing. But Melanie and Yannetti, and the only thing missing was Alessi. But
Right.
it is what it is.
And also, Defense Diaries this morning announced that they are going to be doing a 12-hour fundraiser for Aaron Spencer and his family. Aaron goes on trial next month. I still don't know if
I
there's going to be cameras in the courtroom. I don't know if we've
for
heard anything
some
about that.
for some reason I seem to remember that the new judge had removed that order.
Yeah, I haven't been paying attention, so I don't know. Sadly, I
Yeah.
should be paying attention to this stuff.
Right. I remember something that the new judge, vacated several orders that the old judge put on. And for some reason,
Right.
I think that was one of them. I mean, he vacated the gag order.
Yeah, yeah.
So, okay. Aaron Spencer's trial starts on June 22nd.
Yes. So I don't know if you want to stream that one or if we should just watch with Melanie and do recaps, or because I
I have
was
to
going to watch
stream
with
it.
Okay, we can stream it.
Yeah. I mean, yeah.
I
Yeah,
mean,
I'd like to. Huh?
either way, it's fine. Either way with me. I'm good with streaming
Yeah.
it. I'm going to be home with 3 kids, just FYI.
Yeah, that's well, you know what? That's a month away.
Yeah,
So we'll just see where we are.
yeah, agreed.
I mean, I know the
Okay,
two that I am definitely going to either be in the courtroom for or streaming is the Dr. Tepe, Monique Tepe, and the Ashley Flynn.
right, right.
I'm going to be, if I can't stream it, then I will be in the courtroom.
Right.
And,
And
and Michael, well, his next court appearance is June 17th. So, and Caleb Flynn's trial starts on September 17th.
right,
So,
right.
Michael McKee does not have a trial date yet, just hearings.
Yeah. And just to go over the plan for this week.
Yes.
Today we are doing the Karen Read response to the House Defendant's motion to dismiss, and her response to Tully's motion to dismiss, which is separate. And then
Mhm.
tomorrow we will go over the charging documents in the Enrique Delgado Garcia case. Thursday we will go over, if I can get them, the charging documents for the Faust case. So that way, because there are so many motions, like pre-trial motions in that case, I think the charging documents are just the best way to get a foundation for. And then Friday, we will watch the sit down with Colby and Brandon. Colby Ryan, Brandon Boudreaux. Just as a wrap up to Dava. Well, to Arizona anyway. We're still gonna at some point watch the interview that Nate Eden did with Rob Wood and
Right.
the detectives and all that. And then Monday we will
Right.
start the Faust trial. And this week
Have you heard the latest in Murdoch? He's suing Becky.
Yeah. Melanie went over watched that press conference. Yeah.
I watched it with Runkle last night. I was like, I mean, I
Now,
knew about the book, but she needs like house down in there. Where are you trying to get by a lake house at? Santee?
right? No,
You would have had to sell a whole
Are they
hell of a
suing
lot of
her?
books to buy a lake house on Santee.
Right, right. Are they suing her as an individual, or are they suing the county as
Yes.
well? That okay,
No, just her.
okay.
Yep. Just Becky. Because she's the one who made all the comments to the jury, and then she wrote a
Right.
book. She also made comments that her book would sell really good if he was convicted.
Okay, so
So,
maybe after Faust, we should do Murdoch.
okay. I never actually watched the Murdaugh trial,
Neither did I.
but all right, cool. So it'd be I heard there was some fun moments. So so yeah,
Maybe
I'm down for that. Yeah, the
since he's
Murdaugh,
getting a
the
new trial.
trial. There's no date set yet.
Right, I know that, but the Supreme Court ordered a new trial, is what I mean.
Yes, he is getting a brand new trial. As I'm sitting here playing with my highlighter. He is getting a new trial. No date has been set as of yet. And no date has been set for him suing her, Becky.
Right, right.
And I'm not
That's
sure.
gonna take forever.
Yeah, it is.
That's how
It's
lawsuits are.
small. Yeah. And it's a small town, small
Right,
county.
right,
They don't have a rush button.
right.
They
Kind of
have
like
slow and
Hawaii.
slower.
It's
Yeah.
kind of like Hawaii in that way.
Good morning, Steve.
Good morning.
Thank you so much. Definitely appreciate you being here and listening.
All right. So let's do a song because it's Tuesday, and then we will get into it. How's that sound?
Sounds good to me.
All right, here we go.
Yeah. Monday left a bruise, but you're still in the room. Kiss the sleep goodbye. Pull the daylight through. Phone on silent, shoes on, coffee in a paper cup. You don't need a miracle, just a little push up. Take a breath, count to 3, let the heavy go. One more step, one more street, watch the whole thing grow. Tuesday already, Tuesday already. Look at you go, look at you go. Tuesday already, Tuesday already. Halfway to the glow. Bus stop, cracked sidewalk, sandwich in your hand, small ones in your pocket, better than you planned. Laugh at the bad timing, wave it off and spin. Even on a Tuesday, you can hold it real. Yeah. Take a breath, count to 3, let the heavy go. One more step, one more street, watch the whole thing grow. Tuesday already, Tuesday already. Look at you go, look at you go. Tuesday already, Tuesday already. Halfway to the glow. If the sky turns gray, You still got a flame, tiny little victories, answering your name. So raise it up, right where you are. Tuesday already, Tuesday already. Look at you go, look at you go. Tuesday already, halfway to the glow. Tuesday already, you're brighter than the day. Tuesday already.
Okay. Hey, Shelley.
Love that song. Yes, hi, Shelley. Thank you for stopping by.
Okay, so let's get to this. You read a page, I read a page.
That sounds good to me. So, do you want me to start or you?
You can start because I gotta run to the bathroom.
Okay. Let me check and make sure I have the right one pulled up. Nope. I was going to start on the wrong one. All right. So, this is the motion to dismiss by the House Defendants. Karen Read is the plaintiff, and the whole list, a gamut. Plaintiff Karen Read opposes the special motion to dismiss and motion to dismiss pursuant to Federal R. Civ P 12 B6 ECF number 64. Say that 3 times fast. Filed. I cannot talk today. Filed by what the amended complaint, please. Okay, I'm not muted. Filed by the amended complaint calls the House defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, as set forth in detail below. The court should deny the motion to dismiss under Massachusetts anti-SLAPP statute GLC 231, weird sign 59H, because A special motion to dismiss under the anti-SLAPP statute should not be considered in a federal court pursuant to redacted 607 U.S. 187 146 South Court 546223 LED 2D 463 January 20th of 2026. B, the House defendants' torturous activities go far beyond mere redacted. Okay, this probably is that again, a fucking again. But,
right.
Okay, so mere redacted AC, redacted and, redacted Y2, redacted innits, redacted miss, redacted in, redacted and, redacted exculpating her, and C, the amended complaint plausibly alleges and the attached factual material that the crux of the House defendants' actions were devoid of reasonable factual support or arguable basis in the law and caused Miss Read actual injury.
Okay.
Okay. I'm going to pass it over to you. I'm going to go make myself a fresh cup of coffee. No, I'm going to go make myself a cup of throat coat tea. So I'll be back in just a second.
No problem.
Thank you.
The court should deny the 12B6 motion because A, absolute immunity does not apply to the House defendants' non-testimonial actions of manufacturing and destroying evidence or to their initial statements to first responders that sparked the investigation. B, the statute of limitation began to run when Miss Read was acquitted in 2025, and therefore all claims are timely. C, relating to malicious prosecution claim count 5, the amended complaint plausibly alleges that the House defendants initiated the prosecution by falsely implicating Miss Read in Mr. Peep's murder, unaliving, before the investigation even began. There are ample plausible allegations of lack of probable cause because the House defendants knew Miss Read did not kill Mr. O'Keefe. D. Relating to 42 U.S.C. 1983 conspiracy claim count 3, the amending complaint plausibly alleges a conspiratorial agreement between and among the House defendants and MSP officers Tully, Buchanan, and Proctor, which satisfies the state action requirement of Section 1983. E. Relating to the civil conspiracy claim count 7, the amended complaint contains non-speculative allegations of a common plan by the House defendants to frame Miss Read, coupled with multiple affirmative steps by them to carry out the plan. F. Relating to the Massachusetts Civil Rights Act claim count 4, the House defendants' action in causing Miss Read's prosecution is considered intrinsically coercive under Massachusetts law. These big words, I swear. G. Finally, relating the intentional infliction of emotional distress claim count 6, and the amended complaint goes far beyond simply alleging wrongful arrest but like Lemony versus United States, yada yada yada, involves allegations of knowingly manufacturing evidence to inculpate an innocent person. All right, 1. The House defendants seek dismissal of all state claims against them, count 4 through 7, under Massachusetts anti-SLAPP statute, GL 231 by 59H. The statute authorizes a defendant to file a special motion to dismiss when facing claims based on the defendant's exercise of its right to petition under the federal and Commonwealth constitutions. The statute requires the court to grant a special motion. Hey, Jeannie. Woohoo!
Hey, Jeannie, thank you so much.
The statute, I'll read this page too since I already started it. The statute requires the court to grant a special motion to dismiss based on petitioning activity unless, quote, unless the party against whom such special motion is made shows that one moving party's exercise of its right to petition was devoid of any reasonable factual support or any arguable basis in law, and 2, the moving party's acts caused actual injury to the responding party. Take a drink. In addition, filing a special motion to dismiss stays all discovery unless the court, after a hearing and showing of good cause, allows special discovery. Do you want to start on the second paragraph? Or do you want me to continue? You're muted. Okay. Here the court should deny the
I can take.
Okay.
I was saying I can take over. I just have to
Okay, I
figure out
couldn't
where
hear you.
we are.
Second
No, you're
page,
fine. Okay.
Page 3, second paragraph.
Yeah, I got it. All right. Here, the court should deny House Defendant's special motion to dismiss for 3 reasons. 1, a special motion to dismiss is no longer viable in federal court after the Supreme Court's recent decision in Redacted. 2, the claims in the amended complaint are not based solely on petitioning activity. And 3, pursuant to the pleaded allegations in pleaded. Oh, okay. Well pleaded allegations in the amended complaint and accompanying evidentiary evidence. The House defendants' actions conspiring to manufacture and destroy evidence were devoid of any reasonable factual support or arguable basis in law. A, under the special motion to dismiss cannot be heard in federal court because it requires plaintiff to provide evidence to avoid dismissal. A special motion to dismiss is different than a traditional motion to dismiss. Under Fed R Civ P 12b6, a 12b6 motion is only successful if the motive MOVANT shows the complaint fails Rule 8A2 requirement to provide a short, plain statement of the claim showing the pleader is entitled to relief. Even assuming the truth of the well-pleaded factual allegations, see redacted 640 F3D 112 First Circuit 2011. On the other
Are
hand,
the cases and stuff redacted on the copy that you have?
yeah,
That's weird because they're not online.
yeah.
Anyway, sorry, didn't mean to interrupt you.
No. Yeah, a lot of that is redacted on mine. All right, you know what? I'm going to read this paragraph and then you can take back over.
Okay.
Okay. On the other hand, the anti-SLAPP special motion to dismiss is strong medicine that in part provides the with blank redacted. Oh no, all that's redacted.
That's so weird.
Yeah. Let me see. I could pull it up here. All right, just scroll down to where it starts with presumptive. All right, we're good. Presumptive entitlement is to dismiss unless the opposing party can provide a negative, i.e., under the pleader can, unless, I can't read, unless the pleader can prove the moving party's exercise of its right to petition was devoid of any reasonable factual support or any arguable bias in law, and 2, the moving party acts caused actual injury to the responding party. Bristol Asphalt Company, Inc. versus Rochester Bituminous Prods, Inc. 493 Mass 539 555 2024. To decide whether the non-movement has carried its burden, the court must consider not only the pleadings, but all supporting and opposing affidavits, GLC 231, weird sign, 59H.
Because an anti-SLAPP special motion to dismiss requires a non-movement. Hang on. You gotta take over. I gotta answer this call real quick.
Okay.
Hello.
Come on, baby. All right. 2 seconds. Let me get a sip of this tea from my throat because I'm sure it sounds like crap.
Okay.
Because the anti-SLAPP special motion to dismiss requires a non-movement to provide evidence to avoid dismissal, numerous courts of appeals have decided that similar anti-SLAPP
Table
procedures
that.
are incompatible with Rules 12
Yeah.
and 56
No,
of the
my
federal.
well, my husband's on
Uh,
SSI as well. SSI. Oh, sorry. Oh, my mic is muted. Hang on. I am in the middle of a live stream.
and therefore cannot be applied to federal court. CEG La Liberty versus Read, 966 F3D 7986 2D Circuit to 2020. Collecting cases from the 5th, 11th DC circuits rejecting application of special motions to dismiss in federal court. The First Circuit, along with the Ninth Circuit, is in minority of this circuit split. In Godin versus Shanks, 629 F3D 7985 through 91, 2010. The First Circuit held that Maine's anti-SLAPP statute, me, Rev. Statute, Stat. Tit. 14, weird sign, 556, could be applied in federal court because Rules 12 and 56 did not attempt to answer the same questions nor address the same subject as the anti-SLAPP law. The Court of Appeals interpreted the Maine anti-SLAPP statute to create substantive state law rights to protect petitioning activity by shifting the burden to the non-movement. To establish the movement's petitioning activity had no reasonable bias in the law or fact, and that neither or either Fed R Civ P12 B6 nor Fed R Civ P56 determines which party bears the burden of proof on a state law created cause of action. ID at 89, since Godin, this court, and the First Circuits have adjudicated, special motions to dismiss under the Massachusetts anti-SLAPP statute, which is similar to Maine's CEG Blakesley 158 F 4th at 98 through at 101, reviewing merits district court denial of special motion to dismiss Kirby versus Petite, number 24-CV-12015-8K 2025 U.S. District Lexus 165113 at star 12 D Mass June 24th, 2025. 2 seconds. I need to take another sip.
Can you hear me? I'm back. Sorry about that.
All right. No, you're good. You can continue.
The court should not apply Godin because its holding has been undermined by a recent Supreme Court case. See United States versus Sabetta. That's a 2016 case, noting that it was not bound by First Circuit precedent conflicting with intervening Supreme Court precedent. So many big words. Let's see. The Maine Department of Education, that's a First Circuit 2004 case. Until a court of appeals revokes a binding precedent, a district court within a circuit is hard put to ignore that precedent unless it's unmistakably been cast into disrepute by supervening authority. Oh, hang on. I'll take a break. Okay. In January 2026, the Supreme Court decided Burke v. Choi, which involved whether to apply in a federal court Delaware statutory requirement that state malpractice claims be supported by a complaint at the complaint stage with an affidavit of merit signed by a medical professional testifying that reasonable grounds exist for medical negligence. The Supreme Court held that the state law affidavit requirement could not be applied in federal court because it conflicts with federal RCIP, Fed RCIP P 812 and 56. The court explained that when a federal rule of civil procedure is on point, the district court need not undertake an Erie analysis to determine whether to apply state or federal law. Instead, a valid rule of civil procedure displaces contrary state law, even if the state law would qualify as substantive under Erie's test. The starting question is whether the federal rule answers the question in dispute. If so, the federal rule applies. The court held that the question of whether to dismiss a complaint because it lacked an affidavit in compliance with Delaware law was answered by Rule 8. Because Rule 8A2 requires a short, plain statement of the claim, it establishes implicitly but with unmistakable clarity that evidence of the claim is not required. Quotations and citations omitted. Emphasis in original. That's for the court. The court also noted that Rule 12D provided that a district court cannot consider matters outside the pleadings, but only decide whether the complaint well-pleaded factual allegations state a plausible claim for relief. Thus, Rule 8 sets the ceiling on the information the plaintiffs can be required to provide about the merits of their claim. Accordingly, the affidavit requirement could not apply in federal court. You want me to keep going? I can keep going.
No, I can read.
Okay.
Here, the court should no longer follow Godin because it has unmistakably been cast into disrepute by Burke versus Choi. Just as a Delaware plaintiff alleging the medical malpractice had to provide an affidavit to avoid dismissal of her claims under the Massachusetts anti-SLAPP statute. Because the House defendants supported their special motion to dismiss with testimony, in part, Ms. Read must provide countervailing evidence to show by a preponderance of the evidence that the House defendants exercised their right to petition was devoid of any reasonable factual support or any argument based in law, and two, the moving party's acts caused actual injury to the responding party. See Bristol's Asphalt. 493 Mass at 557. Indeed, the House defendants argue that merely providing an affidavit is not enough and that the anti-SLAPP statute requires the court to resolve disputed issues of the fact on paper record, without discovery, without testimony, and without trial. See Special Mount to dismiss at 22 Bristol Asphalt 493 Mass at 558. This requirement runs afoul of Rule 8, 12, and 56, and should deprive Ms. Read of her right to an right to a jury trial under the Seventh Amendment. The Delaware affidavit requirement conflicted with Rule 8 because under Rule 8, factual allegations are sufficient, but under the Delaware law, the plaintiff needs evidence too. Burke versus Choi, 223 LED, second at 472. The same here. The same is true here. Even though Ms. Read's amended complaint provides a short, plain statement of her claims, and the anti-SLAPP statute also requires her to submit evidence to avoid dismissal. And even though Rule 12D prohibits the consideration of evidentiary material, like the declarations submitted by the House defendants, the anti-SLAPP statute requires consideration of such evidence. Have fun.
Finally, even if the court were to consider the House defendant's evidence and treat the motion as one for summary judgment after allowing Ms. Read the opportunity to take discovery, see Burke v. Choi quoting Celotex Corporate v. Catret. The special motion to dismiss procedure violates Rule 56 of Ms. Read's 7th Amendment jury trial right because the court is required to go beyond considering whether there are disputed issues of fact and instead must decide those disputed issues and determine whether Ms. Read has satisfied a preponderance of the evidence standard. Compare, I have no idea how to say that name. Ehrlich. Is that sound right? Ehrlich. V. Stern, requiring a plaintiff to make those showings by preponderance of the evidence.
It's Ehrlich. Ehrlich.
Yeah. Those showings by preponderance of the evidence requires the judge to assess the strength of competing affidavits, as Aiden likes to say, in marked contrast to her role. When faced with competing affidavits filed in connection with a motion for summary judgment with high-tech.
Have you gone through this?
No. High-tech farm.
It's 1,643 pages.
No, the actual complaint or the actual motion is only 34 pages.
Oh, thank
The
God.
rest of it is testimony. Yeah. The rest of it is testimony.
We don't need to go over that
Exhibit.
stuff.
Yeah,
Just the
exhibit.
complaint. I was like, oh my gravy.
High-Tech Farm Inc. v. Cohen, it's 2016 case requiring a prima facie showing of lack of response or reasonable basis for petitioning activity because deciding between competing affidavit testimony is reserved to the fact finder and absent the parties' waiver of their rights to a trial by jury are not properly within the court's domain. Because Golden's holding is contrary to Burke v. Choi, and because anti-SLAPP procedure for deciding special motions to dismiss conflicts with Rules 8, 12, and 56, the court should not consider the special motion to dismiss. Instead, it should allow the standard 12b6 protocol and simply determine whether the whether the complaint's factual allegations taken as true together with the reasonable inferences taken from those allegations state a plausible claim for relief. My lord.
B. The amended complaint alleges for far more than petitioning activities alone. I'm doing the quotes now. I'm going to do the quotes now. So, why not? What did I just do? Okay. In Bristol Asphalt 493 Mass 539, the Supreme Judicial Court narrowed the applicability of the special motion to dismiss procedure under the anti-SLAPP statute to address concerns that special motions were becoming increasingly common in cases far afield from traditional SLAPP situations. Large developers filing SLAPP suits to silence the local residents, driving time-consuming and difficult legal decision-making at the very beginning of a case while staying discovery and infringing the petitioning rights of special motion opponents. Another change to the law, Bristol Asphalt returned to a narrow and strict construction of the anti-SLAPP statute, such that special motions to dismiss are only cognizable. Okay. When challenging claims based solely on the petitioning, it was the word, petitioning activities. C 493 Mass at 549 through 55. We thus conclude that these powerful procedural protections of the special motion were intended to be employed in the limited context and to ensure the expeditious elimination of meritless lawsuits based on petitioning activities alone. Emphasis added. Thus, the House defendants are required at this stage to show that the challenged count has no substantial bias or basis in conduct other than or in addition to the special motions proponents alleged petitioning activity. ID at 555 through 56. The House defendants have not made this required showing because each of the claims they faced is based on more than petitioning activity. Specifically, in addition to many lies the House defendants told the police, the amended complaint alleges that the House defendants agreed on a simple plan to exonerate themselves and implicates Miss Read. They would tell anyone who required Mr. O'Keefe never entered the house and hid evidence that he was there, including his body. Amended complaint 34. I need you to take over for a second.
Okay. They repositioned a forward edge at a spot adjacent to the front lawn, which obscured the view of the area of the front lawn from potential passerby. Paragraph 35. They carried or dragged Mr. O'Keefe's body to the same area in the yard close to where one or more of them later claimed Miss Read dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Read's vehicle and then died as a result of exposure to the cold. Mr. O'Keefe was either dead when the House defendants left him on the Alberts lawn or died shortly thereafter. Paragraph 36. Miss McCabe directed them to go back to Mr. O'Keefe's home where Miss Read had just come from. The illogical McCabe directed route to 34 Fairview was intentional. It allowed the House defendant more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts front lawn and first responders arrived. Paragraph 39. Jennifer McCabe managed and communicated details about the House defendants' messaging and investigate the investigation itself, including visiting doctors and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, reading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night, paragraph 53. Jennifer McCabe texted with her sister Nicole Albert that Carrie Roberts, who was present when Mr. O'Keefe's body was found, talked to the cops and kept it simple, paragraph 60. While MSP interviewed Roberts, McCabe simultaneously texted her husband Matthew McCabe, Nicole Albert, and Brian Albert, saying she's telling them everything, all the stuff. Nicole Albert responded, good, and called us after, paragraph 56. Whew. Later in the group text with Jennifer McCabe, Brian Albert, Nicole Albert, and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, paragraph 61. Before both interviews, the McCabes and Alberts continued to coordinate their stories as evidence in group text, paragraph 65. Higgins and Albert destroyed their phones despite a state court order or preservation order. See paragraphs 69 through 71. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Alberts property where they would claim Miss Reed dropped off Mr. O'Keefe, the Alberts and the McCabes and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. Paragraphs 178, 190, 196. Shortly thereafter, as part of the plan, Jennifer McCabe deleted a Google search at 2:27 a.m. on January 29th for how long to die it takes a person to die in the cold, paragraph 211. Ms. McCabe also deleted many calls and screenshots on her phone the night of Mr. O'Keefe's death. See paragraph 54. Need a drink.
Okay, I'm ready. I'm back. Thus, the House defendants are simply wrong when they argue that only alleged conduct by each Commonwealth witness relevant to Ms. Reed's alleged injury is the fact that each gave information to the police and testified at Ms. Reed's criminal trial. See memo of law at 9. Okay. In fact, the amended complaint alleges numerous actions by the House defendants that have nothing to do with the statements to the police, such as moving Mr. O'Keefe's body, moving the forward edge to obscure the area where they dragged his body, directing Ms. Reed to travel back to Mr. O'Keefe's house to give the House defendants more time to destroy the evidence, destroying phones, texts, communications. I lost myself. Sorry, my husband came in with a fresh cup of tea for me. I got distracted. Destroy evidence, destroying phones, and text, and communications amongst themselves to coordinate their actions, and deleting Google search evidence. These actions are not petitioning activities, which is defined as any written or oral statement made before or submitted to a legislative, executive, or judicial body, or any other governmental proceeding, and any written or oral statement that made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other governmental proceeding, any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, or any other governmental proceedings, any statement reasonably likely to enlist public participation in an efforts effort to effect such consideration, or any other statement falling within constitutional protection of the right to petition the government. GLC 231, weird sign 9H, emphasis added. In other words, petitioning activity includes all statements made to influence, inform, and at the very least, reach governmental bodies either directly or indirectly. Ehrlich versus Stern, 74, Mass. App at 535, quotations omitted, emphasis added.
As asserted in the amended complaint, most of the House Defendant's activities are not statements. Moving Mr. O'Keefe's body, footnote 1. While the House Defendants maintain that the amendment complaint does not allege certain of the defendants were involved in the moving of Mr. O'Keefe's body, Memo of Law at 11, in fact, amendment complaint does allege that all House defendants were involved. See law. In addition, the amendment complaint alleges a civil conspiracy in which all participants may be held liable for their actions done by others pursuant to common design or with the defendant's substantial assistance or encouragement. Holy moly, that's a long footnote. Mass Laborers Health and Welfare Fund by and through its PRSV Philip Morris Inc. Thus, because all House defendants entered into a common design and plan to implicate Ms. Read by manufacturing scene evidence and destroying other evidence, they are all liable for the actions done by the other pursuant to a common plan, including moving the body and destroying evidence. See Blakesley v. Marcus, affirming district court decision that consideration by the defendants required denial of both defendants' special motions to dismiss, even if one defendant not involved in non-petitioning activity. Obscuring movements of body by positioning the forward edge in front of Albert's house, delaying discovery of the body by redirecting Ms. Read on the morning.
Angie, you were supposed to stop. This is the beginning of a new paragraph on a new page.
Oh, sorry.
It's fine. If you want to continue reading, you can. I gotta go figure out what's going on.
Okay.
I'll be back.
Okay. And destroying phones and Google search evidence do not involve any statement or petition to the government. They involve actions which are not statements. Holding the anti-SLAPP statute did not. See Hen versus City of Yakima. holding that the anti-SLAPP statute did not apply to non-communicative actions taken by defendant. Moreover, much of the conduct was not intended to reach the prosecutors. To the contrary, the House defendants were attempting to hide from them information like Mr. Alberts and Mr. Higgins' phone information and Miss Cape's incriminating Google search. See Blakesley v. Marcus, noting requirement that the communication was made to influence, inform, or at least reach government bodies, either directly or indirectly. I'll just finish this paragraph, and then you can start the next page. At best for the House defendant, this, huh?
Nothing. I realized something, but yeah, no, go ahead. I was wrong. That's all. I was wrong with something, so you just go ahead and continue reading this paragraph.
Okay. At best, for the House defendants, this read claims are mixed claims, that is, those based on proponents petitioning along with substantial conduct are other than or in addition to the petitioning activities. See Bristol Asphalt 493 Mass at 554. The parsing of claims involving a mixture of petitioning and other matters is best addressed in the course of ordinary litigation, where both sides' claims and defenses can fully be analyzed based on a more complete record, not special motions to dismiss. Therefore, the motion should be denied. There you go.
See, if the court finds the amended complaint is based solely on the House defendant's petitioning activity, the House defendant's actions were devoid of factual support or arguable basis in law and caused Miss Read injury. If the court determines that Miss Read's claims against the House defendants are based on their petitioning activity alone, the claims still survive the second stage of the special motion to dismiss analysts, which requires a non-movement to show that the special motion's proponents' exercise of its right of petition was devoid of any reasonable factual support or any arguable basis in the law, and two, caused actual injury to the special motion opponent. See Bristol Asphalt 493 Mass at 557, quotations and alterations omitted. The attached affidavit of Karen Read affidavit and the materials appended to the attached declaration of Damon Seligson December do both. Specifically, they established that the House defendant's statement said Mr. O'Keefe never entered the Alberts residence, or the Alberts house was devoid of any reasonable factual support, and that Miss Read suffered actual injury. She did. Specifically, scroll, please. All right, thank you. Specifically, plaintiff establishes that on this evidentiary record, more likely than not, the House defendants lied about Mr. O'Keefe never entering the home. Miss Read did not strike Mr. O'Keefe with her vehicle. See Read affidavit, paragraph 5. Again, for the people in the back. Miss Read did not strike Mr. O'Keefe with her vehicle. I don't think they get it, though. The Massachusetts chief medical examiner testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, but rather a physical altercation. See testimony of Dr. Ernie Scortabello, Attach 1 to Seligson declaration. Mr. O'Keefe did not show signs of a physical altercation before Miss Reed dropped him off, and he and Miss Reed did not have such an altercation before she dropped him off at the Alberts house. See Reed Affidavit, paragraph 6. Mr. O'Keefe also suffered a quadruple wounds on the back of his head, which is consistent with falling on the ridge surfaces presented in the Alberts home garage. See testimony of Dr. Irene Scortibello, attached 1 to Seligson's declaration. Can you scroll, please?
Mhm. Sorry.
No, you're fine. Mr. O'Keefe also suffered dog bite wounds, and the Albert German Shepherd has a history of aggression. See testimony of Dr. Ernie Scorabello, attachment 1 to Seligson's declaration. In addition, evidence was presented at Miss Reed's trial that Mr. O'Keefe's phone was at some point inside the Albert's home. See testimony of Ian Whiffen, attachment 3 to Seligson's declaration. And finally, the evidence that Miss Reed's trial also revealed that Miss McCabe had used her phone to search at 2:27 a.m. 2:27 a.m. on January 28th. How long it takes for a person to die in the cold. Hassan to die in cold at 2:27. See testimony of Richard Green, attachment 10 to Seligson's declaration.
Mhm.
Want me to continue?
Please, I'm almost done eating. Sorry.
You're fine. You want me? I didn't get your answer. Do you want me to continue or?
Yes, please. I have food in my mouth.
Oh, okay. In addition, and without any discovery yet in this action, the court should take into consideration that the House defendant have already been caught making misrepresentations and attempting to cover up their conspiracy. Brian Higgins, Mr. Higgins, originally told police he went to the Canton Police Department on the morning of January 29th to do administrative work in the middle of a snowstorm. See testimony of Brian Higgins, attachment 13 to Seligson's declaration. Mr. Higgins then told the grand jury and said he went to the Canton Police Department to move cars around. CID attached 6 to Seligson's declaration. Yet later at trial, video evidence showed Higgins moving a large parcel from one vehicle to another, disappearing into his office, and then spending a period of time in another unseen area of the Canton Police Department, and then finally exiting the Canton Police Department. See Canton Police Department Incident Report, attachment 7 to Seligson's declaration. Mr. Higgins testified that he did not speak to anyone after leaving the Alberts home until he was notified of Mr. O'Keefe's death in the morning of January 29th. See attachment 13 to Seligson's declaration. However, evidence at trial showed that he and Brian Albert had communicated by phone at 2:22 a.m. that morning before Mr. O'Keefe's body was found. See Call Higgins Albert logs, attachment 2 to Seligson's declaration. Nicole and Brian Albert, on January 29th, they told Sergeant Lank that their daughter, Caitlin Albert, was only briefly at the Albert's house and left around 12:15 a.m. See Canton Police Department's at page 8, paragraph 6, attachment 6 to Seligson's declaration. However, Caitlin was later interviewed by Massachusetts State Police and said she was the last to leave their 34 Fairview. C. Massachusetts State Police interview with Caitlin Albert. Attachment 11 to Seligsohn's declaration. Trial testimony by all the House defendants confirmed Caitlin was the last to leave the Alberts house around 2 a.m. See transcript of trial testimony of Jennifer McCabe. Attachment 8 to Seligsohn's declaration. Can you scroll? All right, thank you. You can scroll up one more, a little bit more. All right, there. Nicole Albert told police she was asleep until Miss McCabe came into her bedroom just before 7 a.m. January 29th. See transcript of trial testimony of Nicole Albert, attachment 14 to the Seligsohn's declaration. However, call logs show a 38-second answered call from Jen to Nicole at 5:06 and 21 seconds a.m. See Jennifer McCabe. Phone records at page 11, attachment 12 to the Seligsohn's declaration. Nicole Albert testified before the grand jury that she went to bed as soon as everyone left her house. See attachment 4 to the Seligsohn declaration regarding grand jury testimony. Yet, Brian Albert testified before the federal grand jury that he and Nicole Albert were not only wide awake, but having intimate relations, a little smexy time at 2:22 a.m. when he was talking to Brian Higgins for 22 seconds. See attachment 4 to Seligsohn's declaration, paragraph 12 regarding the grand jury testimony. Brian Albert testified that he did not make any calls during the night of January 29th, but call logs show activity between him and Brian Higgins at 2:22 a.m. See Brian Albert's trial testimony, attachment 9 to Seligsohn's declaration. Are you ready to take back over? Or do you still need a few minutes?
I got like 3 bites left.
Okay, I'll do Jennifer McCabe. You're good. Jennifer McCabe. Miss McCabe falsely identified herself as Nicole when interviewing FBI agents and falsely told them that she had not made any phone calls in the brief period after the agents first showed up and then returned for questioning. See Jennifer McCabe trial transcript, attachment 8 to the Seligsohn declaration. No, it was just a bunch of Hi, Sanity Hack. This is the call that Nicole calls Julie Albert. Julie Albert tells jury she finds out John died at 5 o'clock or the second case of prior knowledge along with 227. Yeah. No, 227 is never going away. Never. All right. My screen back up. Sorry. I just saw that come up. After threatened with the penalties of lying to agents from another organization, Miss McCabe admitted to calling her husband, Brian Albert, Peggy O'Keefe, and Adam Lowley. See attachment 8 to Seligsohn's declaration. She also called Carrie Roberts. Miss McCabe admitted during her trial testimony that she went to Sergeant Lank's house on January 30th until the defense presented her phone's location data. See attachment 8 to Seligsohn's declaration. She also testified that she drove straight to Sergeant Lank's house from the O'Keefe's house, but her path of travel showed that she went directly to Sergeant Lank from her own house after stopping at the Albert's house. See attachment 8 to Seligsohn's declaration. She also denied ever stopping at the Albert's house, but the phone data at trial revealed a 5-minute stop on the way to the Sergeant Lank's residence. The attachment 8 of the Seligsohn's declaration. Miss McCabe falsely told first responders that Miss Reed said, "Could I have hit him?" See attachment 8 to the Sultan's declaration. She later testified at trial that Miss Reed said, I hit him, I hit him, I hit him. See attachment 10 to the Sultan's declaration. Are you ready?
Yes. Okay.
You're muted.
Am I? No, I'm not. Can you hear me?
No, you're not. I can hear you now.
Okay. Okay. I'm like, I see the green thing moving. Yeah, I saw those.
Yeah.
Sorry. My bonus daughter is graduating, so
Mhm.
she was showing me pictures.
Aww.
Okay. In support of their argument that they had reasonable factual support for any arguable basis in law to tell first responders, investigators, and juries that Mr. O'Keefe had never entered the Albert's home, the House defendants offered two sources of evidence. The Commonwealth statement of the case after Miss Reed's indictment and their declarations. Each failed. The statement of the case does not offer competent evidence since it is not a sworn statement based on personal knowledge. Excuse me. Oh, I was not expecting it to be that big. That's what she said. Anyway, but simply contains allegations the Commonwealth intended to prove at trial. Hang on. There's a footnote. The House defendants argue the statement of the case can be considered as matter of public record. Memo of law at 32 and 8, citing, oh my lord, how do you say that? Jiragosian v. Ryan, the 2008 case. The public record exception to the rule that 12b6 motions are to be decided based on the pleadings and incorporated documents generally allows a court to conclude that the record exists. The exception does not allow the court to treat all information in the record as true. Thus, the court should not consider the statement of the case for the purposes proffered by the House defendants. The truth of unsworn allegations in the statement with respect to the House defendants' declarations, with respect to the House defendants' declarations, the court should not credit them for two reasons. First, a coordinated statement that Mr. O'Keefe did not enter the Albert's house is contradicted by the evidence submitted at Ms. Reed's two criminal trials. Second, because the House defendants have a documented history of making false statements, they are not credible witnesses. Dang! Relating to her injuries, Ms. Reed easily establishes her actual injuries inter alia, including loss of employment income and millions of dollars in legal fees to defend herself, emotional harm, and exasperation of her multiple sclerosis and Crohn's disease symptoms. See Reed affidavit paragraphs 8 and 9, testifying to injuries and expenses and losses suffered as a result of prosecution. Nor do the House defendants special motion even argue Ms. Reed did not suffer actual injury or contest that their actions and statements led to the wrongful prosecution of Ms. Reed. Therefore, Ms. Reed satisfies this element too. Number 3. Okay. Okay, we're on 16. The court should deny the 12-6 or 12B6 motion. Unlike the House Defendant's special motion to dismiss pursuant to the statute, their motion pursuant to Rule 12B6 is subject to the well-known standard, which assumes the truth of the plaintiff's allegations and takes all reasonable inferences in the plaintiff's favor. A. Absolute immunity does not shield the House Defendant's actions or initial statements. Yeah. Sorry, I am blind today. What Jen was talking about. Right. First,
I'm
the
muted.
House. Yes, you are. Or you were.
Not anymore. You can't silence me. Only I can
Okay.
silence me. And I do it a lot.
So I already planned this out in my head. We are on page 16. I want to get through 17. Okay, we'll get through 17, the paragraph, the last paragraph before this, end at memo of law at 25. Then we're going to take a dance break.
Okay.
This is a lot of reading.
It is.
Okay. First, the House defendants contend that all the claims against them are barred because they are absolutely immune from liability arising from their testimony in judicial proceedings involving Ms. Read, as well as statements made to the police prior to those proceedings. See memo of law at 23 through 25. But that misses the point entirely. Ms. Read's claims against the House defendants involve far more than their false statements and testimony, and these other actions are not immune. Pursuant to absolute immunity doctrine, I don't even know if we're going to finish the Tully one before nap time. I know, y'all. I cut it off at 12. I'm sorry. I'm tired. But that 12 is it. Just saying. This mama's tired.
Another hour.
Sorry.
Yeah, it's taken us an hour and a half to get this far.
Yeah.
We may not finish this one, but oh well. If we don't, there's tomorrow.
Yes. Pursuant to absolute immunity doctrine, defendants are immune from Section 1983 claims when based on the witness's testimony or an alleged conspiracy to provide false testimony, and evidence of the witness testimony may not be used to support a Section 1983 claim concerning the imitation or maintenance of prosecution. See Rayburn versus Hulk. However, absolute immunity does not extend to all activities that a witness conducts outside the courtroom. Haha. Specifically, the Supreme Court in Rayburn made that clear that absolute immunity does not apply to non-testimonial actions like falsification of an affidavit and fabrication of evidence of a crime. the Buckley v. Fitzsimmons. Fitzsimmons has entered the chat, and that is
Not the same one, though. Not the
no,
same Fitzsimmons.
that's a 1993 case. Respondents have not cited
She even born. No, she wasn't even born yet.
right, any authority that supports an argument that prosecutors' fabrication of false evidence during the preliminary investigation of an unsolved crime was immune from liability at common law, either in 1871 or at any date before the enactment of 1983. Right, I agree. Thus, while the House defendants may not be held, stupid orange juice making me burp, may not be held liable for their false statements to the grand jury and false testimony at trial. They do not have immunity for their false actions falsifying evidence by moving Mr. O'Keefe's body and manufacturing and destroying evidence. These actions lie in the heart of every claim against the House defendant. The amended complaint, paragraph 168, destruction of phones, 178, 190, 196, 211. Gosh, this thing is thorough. Like, I know Melanie went over it, but sheesh.
Yeah, well, so we're not lawyers or lawtologists or
Yes.
paralegals or judges or government
Although
officials. So,
I did go to school to be a paralegal. I just never finished. Moreover,
Yeah.
absolute immunity does not
Hey,
apply.
hey, it's my turn.
Sorry. Go
Mute.
ahead.
Scroll up. Can you scroll it up a little?
Yeah.
There we go. Okay. Yeah, and I'm just reading till 25, right?
Yes.
Just this paragraph.
Yes.
Moreover, absolute immunity does not apply to the false story they told the police prior to or at the very start of the investigation. Jesus. Into Mr. O'Keefe's death, including the claim that Mr. O'Keefe had never entered the house and that Miss Read had made inculpatory statements on the morning of January 29th. See AM complaint, paragraphs 41, 45, 47. The SJC has made clear that not all reports of a crime are absolutely privileged. The critical question is whether, at the time of the defendant's statement, a criminal or a judicial proceeding was then being contemplated or proposed. Cornelius versus Viverosa. Yep. 410 Mass 314 323 1991. In borderline cases between unsubstantiated reports of criminal activity and statements made in the course of proposed judicial proceedings, a careful fact-specific, analysis is required. CID. The House defendants significantly overstate the law when they claim the absolute privilege extends to these additional statements because they're pertinent to judicial, that word, proceedings as a matter of law. Memo of law at 25.
Yay.
And at 25, it's time for a dance
break. Okay, now I am leaving this up to the chat.
I'm gonna say, cousin.
Okay, do we want, because I'm going to save my other Karen Read song for the outro, do we want 508 Justice? Put a 1 in the chat for 508 Justice. put a 2 in the chat for never poke a turtle. No responses. Okay, I guess we're going with never poke a turtle. Thank you, Malin.
You're welcome. Hey guys. Yeah, vote. What's up? What's up with this? Gotta vote. Never poke a turtle, number 2.
And
Or
508.
508 justice is
Or-
number 1. 1 for 508 justice. 2 for never poke a turtle. Two, sanity. They want never poke a turtle too.
Okay.
So going once, going twice, sold 2. Never poke a turtle.
All right, here we go.
From Boston fog to courthouse stone, Aiden wore the truth like a coat. He dug through lies and copied files till the whole damn paper started to glow. He found the name of Officer John, found the edits, found the bloodless lines, found the hands that scrubbed the page and the grin they wore when they sold that lie. They said, let it sleep. They said, walk away, but Aiden kept the receipts in a drawer that shook all day. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. Commonwealth came with polished words and suits that fit a guilty frame. They leaned on names, they bent the facts, tried to bury John, then bury the blame. Aiden stood in the floodlit hall with his notes and a jaw like iron. He said, if you want this dead and gone, you'll have to kill every page I'm on. They locked the door, they raised the heat, but every thread they poured only sharpened what he'd see. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. You can hide for a while, but you can't hide forever. And late came the lesson, too late for their hands. What moves in the dark still leaves marks in the sand. Aiden from Boston still stands in the rain. One man, one story, and a city saying names. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. You can hide for a while, but you can't hide forever.
All right, we are back. Thank you, Mitchell. Okay.
Hey, Mitchell. Hey, Garth. Thank you guys for coming and listening. Angie, are you talking?
Can you hear me now? Yes, you can.
Yes, Jenny. Rip Officer John O'Keefe.
Yeah. Okay.
Angie?
Can you hear me?
Now I can.
Okay. Okay. So here, no criminal or judicial proceedings were contemplated or proposed at the time the House defendants made their statement. Ms. McCabe initiated the 911 or the call to 911 reporting a man passed out in the snow. I can't do the accent.
There's a man passed out in the snow.
the Alberts and McCabe's then falsely told one of the first responders on the scene that morning, Sergeant Lake of the Canton Police Department, that Mr. O'Keefe never entered the house. See paragraph 45. Miss McCabe then reached out to Sergeant Lake later to falsely say that Miss Reed said that morning, "I hope I didn't hit him." And then see paragraph 45. Unlike the timing in Corella, where the relevant statements were made when a criminal investigation was well underway, 410 Mass at 2324. Here, the statements were made prior to investigation by the state police and to one of the first responders on the scene. The statements to a first responder before an investigation was underway that are consistent with the efforts to fabricate evidence before police know of the crime. It's more akin to cases where the defendants went to the police and or communicated with others on their own initiative and published an accusation which might otherwise never have been known. Corellas v. Viveros 410 Mass at 322. Thus, at this early stage, prior to discovery and assuming the truth of the allegations in the amended complaint, allegations. Why am I getting so messed up? The House defendants have not carried their burden of establishing an absolute privilege to make their false statement to police officers on the scene. Do you want to read or do you want me to finish the page?
I can pick up from here.
Okay.
B. Miss Reed's claims against the House defendants are timely because they were filed less than 3 years after she was acquitted. After her acquittal. Yeah, no duh. The House defendants next argue that Miss Reed's claims are untimely because she failed to assert them in the midst of her 3-year criminal prosecution, based in large part on the House defendants' statements and conduct. According to the House defendants, Miss Reed learned of their conspiracy to frame her by June of 2022. And the statute of limitations began to run at that time, even though the criminal case they wrongfully helped initiate and sustain did not terminate up until her acquittal in June 2025. See memo of law at 26 through 30. However, simply is not the law. In fact, the Supreme Court has explicitly rejected this argument and held that a criminal defendant like Ms. Reed, can you scroll?
Yeah. Sorry.
Scroll, please. There we go. The defendant, like Ms. Reed, is not required to assert her civil claims while still defending herself against that prosecution. That rule would create practical problems in jurisdictions where prosecutions regularly last nearly as long as or even longer than the limitations period. Criminal defendants could face the untenable choice of letting their claims expire or filing a civil suit against the very person who is in the midst of prosecuting them. The parallel civil litigation that would result if plaintiffs choose the second option would run counter to the court principles of federalism, comity, consistency, and judicial economy. McDonough versus Smith. This makes sense because in the early stages of prosecution, a defendant cannot know whether their prosecution is actionable because the defendant has been neither convicted nor acquitted. If convicted, no claim would exist at all. Savory versus Cannon, 947 F3D 409 427 7th Circuit 2020. Without favorable termination, a plaintiff lacks a complete and present cause of actions. Quotations omitted, but they're there. Anyways, thus the defendant would be forced to file a civil claim before a cause of action even exists. Moreover, requiring defendants to pursue parallel civil litigation while simultaneously defending their criminal case would put undue burdens on defendants and potential prejudice their defense. The defendant risks tipping his or her hand as to his or her defense strategy, undermining his or her privilege against self-incrimination, and taking on discovery obligations not required in the criminal context. McDonough, 588 U.S. at 120. This approach would also invite collateral attacks on criminal proceedings, risking inconsistent rulings between the civil and criminal courts. Heck versus Humphrey, 512 U.S. 477, 484 through 85, 1994. For these reasons, claims premised on false evidence and infirm prosecutions do not accrue until the underlying criminal proceedings terminate in the defendant's favor. Neves versus McSweeney, 73, F support 2D 98, 104, D Mass 1999. Section 1983, conspiracy to commit malicious prosecution, Billings versus Commerce Inc. Co. 458, Mass 1994, 1998, 2010, common law malicious prosecution, Murphy versus Goslin, number 25 CV 10266-ADB 2026, U.S. District Lexus 3500007. At star 60, Mass, February 19, 2026. Claims for malicious prosecution under common law, Weird Sign 1983. And the MRCA and the MCRA are similar in that they each accrue when the underlying criminal action terminates. Harris versus City of Everett, number 19-10537-JGD 2019 LWL 6528889 for 2019 U.S. District Lexus 209532 at Star 35D Mass, December 4th, 2019, denying dismissal of emotional distress claims and noting courts have allowed claims of intentional infliction of emotional distress to proceed, along with the malicious prosecution claims many years after a conviction, where the conviction was later overturned. Here, Ms. Read's claims against the House defendants are timely because they did not accrue until her acquittal of June 2025, when the underlying criminal proceedings terminated in her favor. If you want to take over, you're more than welcome.
Yeah. To avoid this conclusion, the House defendants attempt to recast the amended complaint. As alleging only that they participated in a conspiracy to have plaintiff wrongfully arrested, rather than the larger conspiracy described in the amended complaint's many allegations. See Memo of Law Act 19. According to the House defendants, this means Ms. Read's claims occurred in June of 2022, when she learned of the false statements leading to her arrest. The Neves 73 federal something at 103 to 104 claim for conspiracy to commit wrongful arrest occurs at time plaintiff learns of injury, while claim for conspiracy to commit wrongful prosecution occurs at termination of underlying proceedings. Contrary to the House defendant's argument, however, count 3 through 7 of the amended complaint expressly allege that the House defendants participated in a conspiracy to maliciously prosecute Ms. Read, not merely to have her wrongly arrested. The amended complaint contains many allegations that go beyond false statements intended to cause the police to arrest Ms. Read. For example, the House defendants coordinated amongst themselves to provide false statements and ultimately false testimony, including that Mr. O'Keefe never entered the house, and that the plaintiff told Ms. McCabe, "I hope I didn't hit him." And then they see paragraphs 45, 47, 63. The night of the murder, Brian Higgins and Brian Albert called each other multiple times to coordinate their stories. Ms. McCabe performed a Google search for "Hot Song to Die in the Cold," paragraph 38. The House defendants also collaborated to hide evidence, moving Mr. O'Keefe's body and repositioning a vehicle to obscure the crime scene, paragraph 35. Then, during the prosecution, Brian Albert and Brian Higgins destroyed their cell phones after Ms. Read's defense team requested to preserve them. Throughout the criminal proceedings, the House defendant...
I can take over. Throughout the criminal proceedings, the House defendants continue to coordinate their stories with police. Proctor, the lead investigator, repeatedly communicated with the House defendants through his sister, helping to coordinate their stories and pass along details of the investigation before they were public. ID, paragraph 8, 73 through 77. Indeed, Proctor was close friends with the Alberts and met with Miss McCabe at his private residence during the investigation. ID, paragraph 53. The House defendants and their families' frequent interactions with Proctor outside the normal protocol simply support an interference that the that the House defendants conspired with inference. There you go. I couldn't get it. It's inference. that the House defendants conspired with the police throughout the prosecution. Thus, because Ms. Read's claims allege harm from wrongful prosecution, not just wrongful arrest, they accrued when Ms. Read was acquitted, and therefore timely. C. Amended complaint possibly pleads a malicious prosecution claim. The House defendants make 3 arguments for dismissal of the count 5, the common law malicious prosecution claim. None warrant dismissal. First, the House defendants argued they did not commence or continue the prosecution because Ms. Read fails to allege that the House defendants took an active role in her investigation or prosecution, and she does not assert that they indeed induced or pressured law enforcement to arrest Read in any way. Memo of law at 31. This misstates the law. In fact, the contrast between the facts alleged in the amended complaint and those before the court in the case of the House defendants rely upon liminal versus United States 579 F3D 7990 First Circuit 2009 illustrates why Limon applied Corellis versus Viverois, holding that merely providing information that an investigating officer is not actionable and that the defendant must have in some sense initiated the prosecution. Cornelius Fortin, Matson, 318 in Lemoyne. The First Circuit rejected a malicious prosecution claim against the FBI agents accused of shoring up the false story that was initially provided by a witness in a murder investigation. The malicious prosecution claim failed because there was no proof of defendants voluntarily reached out to law enforcement officials and caused them to commence a new line of inquiry, ID at 90. Yeah, the irrelevant footage.
Right. Ms. Read's amended complaint alleges the exact opposite. The essence of her malicious prosecution and related claims against the House defendants is that they initiated the entire prosecution by casting Ms. Read as the suspect before the investigation started, even before the investigation started. Ms. Read alleges that the House defendants directed first responders and investigators to Ms. Read almost immediately, and the investigators willingly took the bait as part of the concerted plan to distract from their own guilt. And among other things, they moved Mr. O'Keefe's body to the front area of the Alvarez house, where they later claimed to have seen Ms. Read drop off Mr. O'Keefe's the amended complaint, paragraph 35. Ms. McKay voluntarily reached out to a police officer responding to the scene several hours after the body was found, saying that Ms. Read said twice, I hope I didn't hit him, paragraph 47. The House defendants then coordinated the story that Mr. O'Keefe never entered the house. Paragraphs 38, 53 through 56, and 167. Mr. Higgins and Mr. Albert destroyed their phones, and Ms. McKay deleted her Google search history to hide any incriminating evidence. Paragraphs 70 to 72 and 168.
Accordingly, the amended complaint plausibly alleges the House defendants initiated the prosecution when they concluded to focus the police on Ms. Read before investigators even appeared on the scene, cemented their efforts by reaching out to Proctor and others with false statements after the investigation commenced, and then corrupted the ongoing investigation by coordinating stories and destroying evidence that exculpated Miss Read. Not surprisingly, and as planned by the House defendants, the Alberts family friend and lead investigator Proctor, who was not on call that day, focused solely and exclusively on Miss Read from the very first hours of the investigation. CID paragraphs 5 through 6, or just look at its text. Because the amended complaint plausibly alleges the House defendants initiated the prosecution, the malicious prosecution count states a claim under Massachusetts law. See also Patrica versus the City of Gardner. 429 F supply 2D 216 225 D Mass 206 2006 denying summary judgment where the plaintiff alleged the defendant made knowingly false statements about him under public of under oath in support of the criminal complaint. Restatement second of torts we're signed 653 CMTG in order to charge a private person with responsibility for initiation of proceedings by a public official. It must therefore appear that he his desire to have the proceedings initiated expressed by direction or request or pressure of any kind, which the determining factor in the official's decision to commence the prosecution, or that the information furnished by him upon which the official acted was known to be false. Emphasis added. The House defendant's second and third argument overlap. They contend that the amended complaint fails to establish a lack of probable cause and fails to show that the House defendants acted with malice. See memo of law 32 through 34. The malice argument is not developed, but instead reliant on the lack of probable cause argument, CID at 34. Those same reasons why the malicious prosecution claim fails under prior to elements demonstrate how Miss Read fails. Can you scroll? Fails to show that the House defendants acted with actual malice. The argument boils down to a single assertion. Any reasonable person have suspected Miss Read's culpability. ID at 33. The House defendants then cite that they say, and it is what they say is incriminating evidence. Her presence that night before in the area Mr. Keith's body was found the next day, a cracked taillight on Miss Read's car, and her seeing the body immediately upon returning to the Alberts house the morning of the January 29th ID. Girl, my throat's done.
Okay.
So if you want to finish reading, if you want to finish reading this page, and then let's call it for now, because at this, I keep going. I'm not going to have a voice tomorrow.
Okay. The argument fails because it ignores the salient allegations in the amended complaint. Ms. Read alleges that the House defendants were responsible for Mr. O'Keefe's death based on the injuries to Mr. O'Keefe consistent with being attacked by the Alberts dog, hitting the back of his head on a ridge surface like those present in Albert's garage. I don't know if it was the garage though. Have you seen, side note, have you seen Samantha's videos lately?
Yeah, I've seen some of them.
Where she talks about the fireplace and how John could have hit his head on that.
Yeah, I did see that.
Okay, sorry. The amended complaint also alleges the House defendants tried to hide their.
Oh, if I could drink. No, you're fine. Unfortunately, I cannot drink tequila.
Where was I? Oh, the amended complaint also alleges that the House defendants tried to hide their guilt by moving Mr. O'Keefe's body in order to incriminate her. Paragraph 34 and 35. These allegations which must be accepted as true for purposes of the motion to dismiss, paint a textbook case of lack of probable cause. The complainant knew the person they were implicating was not responsible, as the restatement provides. A private prosecutor cannot have probable cause for initiating criminal proceedings against another if he does not believe that the accused was guilty of the crime charged against him, or in this case her. If he does not so believe, it is immaterial that the facts of which he has had knowledge or belief were such that reasonable men might have regarded them as proof of the guilt of the accused. See restatement second of towards section 6.2. I think it's section. That's what the weird symbol is. CMT.C. As the House defendants correctly explained in their motion, their conduct must be adjudged by their honest and reasonable belief at the time he instituted the complaint, rather than what may turn out to have been the actual state of things. Memo of Law 32, citing Wingan versus Shea, which is a 1972 case. All right, I'm going to finish this paragraph and then we'll be done. For
Yes.
a 12b6 motion, that honest and reasonable belief must be determined on the basis of the allegations in the complaint and the reasonable inferences in the plaintiff's favor that spring from such allegations. According to the amended complaint here, the House defendants knew at the time they conspired to incriminate Miss Read that she was not responsible for Mr. O'Keefe's death. Thus, they lacked probable cause for their investigation of Miss Read's prosecution. I am not reading that whole thing. Nope. Okay, we're done.
Yeah, we're done for today. I was trying to see if I could find that symbol.
If I remember right from school, all the schooling I did, it's section, which makes sense because it's a section 1983 claimed is usually what you hear.
Yeah.
So, okay, so
Yeah, and I mean, it looks like a, S type thing.
yeah.
So,
Well, it's a good thing because I get to take a longer nap today.
mhm. Yeah,
So,
you said that weird one is section. Yeah, you do. So, I want to thank everybody for coming today. Definitely appreciate all of you for coming. Thank you for subbing. Angie, you got one sub, so you're up to 275, and I got one, so I'm up to 126.
Yay.
So I'm so excited. My goal for this week is to get to 130. And my goal for Angie is to get her to 80. So we appreciate it. Please definitely like, share, subscribe. All the YouTube things. Thank you guys for coming. Tomorrow morning, I will be covering Kid Kane. Yes, you have a good afternoon too. So tomorrow morning, I will be covering Kid Kane before me and Angie do stream it together again. So I look forward to seeing everybody there. As always, go out with all the love and peace in your heart. My beautiful butterflies, please make sure you pollinate the algorithms.
Okay, so everything social media wise is NGM 1984 YT. I'm just gonna say that from now on. Hey, bless Texas, Ollie. Thanks for coming.
Yeah, thank you so much for being here.
Other than Facebook, which is Angie Mead, cash out or donations are never required, but always appreciated. Cash out $sign NGM 1984 YT, Venmo at NGM 1984, buy me a coffee at GM 1984. There is an Amazon wish list that I need to put in my description, but it's for to keep summers coming up. Like the kids, our girl twin has only 2 days left of school, and the other two have 6 days left of school. So they definitely will need, if you want to, it's not required, but if you want to, there are like educational things on the wish list for them to keep them busy while I am streaming during the summer. So
I'm
yeah,
gonna go ahead. I'm
everybody-
dropping that back in the chat.
Everybody have a great day, and remember tonight it is Turtle Boy Tuesday, so Aiden has the show at 9 o'clock, I believe, Eastern.
And then right house tests are usually starting between 6 and 6:30. Yay, my camera loves me, can't you tell?
And then yeah, Rat House Media most likely will have
It
a
always seems
pregame.
to be up close and personal.
And yeah, so we will see you tomorrow.
do
So
now. I
little
got
bit of a change of plans. I think tomorrow we will finish this, and we will, depending on how long the Tully one is, we'll do that, and then maybe start Enrique stuff, and then Thursday we will do Enrique and Edric. How about that? And then Friday again, Brandon and Colby. So yeah, everybody have a great day, and we love you, and we will see you all in the chat. See you later, everyone.
Yep, see you guys.
John in a worn out coat, Karen with a borrowed book, by the old library stairs, one look and the whole world shook.
Back when the dorm lights glowed, back when the road felt new, they laughed in the rain at dusk and swore they'd make it through.
Then time took the letters and miles took the rest.
2 lives went quiet with words left unsaid.
John and Karen, John and Karen, love came back again. John and Karen, John and Karen, then the ground gave in. 2 years and a little home, coffee rings on the wood, his keys by the bowl still set like he said he always would.
Then came that awful night, glass sirens shaking hands. He lay there gone too soon, and she lost the floor she stands.
They asked her 1,000 times, like she knew the knife. Now every courtroom wall feels like borrowed life. John and Karen, John and Karen, love came back again.
the one who took him, can't hide from her no more.
John and Karen, John and Karen,
Love came back again.
John and Karen, John and Karen, she'll bring justice in.